Good afternoon, everyone. This is Zach Lucas at Spencer West, just to bring us in early on this follow-on session for the Family Office series of talks. Today, we're dealing with the Family Office dispute. Now, again, I'm very happy to be joined by David Brownbill, QC. As mentioned in some of the sort of invitations, David has been involved in very high-profile cases over the years, and is obviously still active in the profession and dealing with cases as we speak. And so we're very lucky to have David along to share his knowledge and experience with us on dealing with this particular topic, this emotive topic of family office disputes. Now, for today's session, the recording as well as the podcast will be sent around. If you've registered, you're watching, then that will be sent around after the event. And the usual admonitions, as with all these talks, is that it's not to be relied upon as legal advice or constituting legal advice. And it's not warranted as being error-free, although it's probably not going to be in any way an error. But just moving on to the agenda for today. The overview really is just going to set out how to manage the family office dispute. And you'll look at it from two different angles. One, dispute avoidance, which is what should we be doing to try and avoid getting into a dispute in any event? And then when a dispute happens, what's the best practice going forward? And then looking at the typical tools that are deployed, typically in these environments. So looking at the unstructured family office first, and that for us, and I'll explain more about this later on, means effectively a directly held family office, so shareholders. And then the structured family office, which seems to be a very sort of topical and common practice, particularly in Southeast Asia, which is a trust, effectively a trust holding or ultimately holding the ownership of the family office group of companies. Now, we've added in the hybrid family office, and this is where clients have opted for a mix. So they'll have a trust, but also some family members will hold direct shares in the family office. So a hybrid version is an important consideration. Some of you who are following me on LinkedIn will see that I've been running a number of polls on this. And it's quite surprising that on the poll for which is the typical structure that families adopt, the two are neck and neck between structured trusts and hybrid, which is trusts and direct ownership. So it's an interesting one that we'll wrap up on as we go into the summary of the discussion. And then if we have any time, some Q&As, be about an hour as usual, hour 15 minutes, and then we'll spend some time at the end canvassing any questions that come up on the chat. Okay, so going into the overview, just introducing what we're about when we're talking about family office disputes. As I said at the beginning, dispute avoidance is the gold standard. This is what we're trying to achieve when we're structuring clients in the first place. We're not structuring them so that they do well in court. We're trying to get them, if we're already in court, then probably the governance mechanism that we've agreed has failed in some way. And that's what we should be saying to ourselves, that we should try actively to have a dispute avoidance mentality. And I'll go into what some of that will entail in terms of the governance frameworks that would need to be adopted. And then we'll look at dispute management, and typically how dispute management is dealt with, contrasting both a shareholder arrangement with a trust as we go through it. So governance frameworks. This is an important topic. It's talked about a great deal, but I think people struggle with what's exactly meant by a governance framework. If it plays such a significant role in dispute avoidance and the general framework of holding the family together in these family offices, then what do we mean by a governance framework? So I'll first introduce the diagrams, and then we'll start to talk about the governance framework. So this diagram represents directly held shareholders in a family office. I've adopted the usual Singapore style of a holding company with a fund management and a fund company. Those of you familiar with this is the diagram that's typically trotted out by MAS in their FAQs, for instance. For a structured family office, this is just a trust holding at the top. And then we have the usual beneficiaries, separable protectors, and then the company below, the family office structure below. And the hybrid is a mix. So we have two shareholders and a trust, and they're all effectively cohabiting on one centralized company. So coming back to it, these are the structures that we'll be analyzing. But then when we're looking at the governance framework that applies, then without going exhaustively into this, because this would be a session or a couple of sessions actually on its own, what we're looking at is typically the families having to agree 4 key areas when they're arranging their framework. And I'll ask David to chime in on this, but I'll just do a summary of what these areas entail. I've got them listed there. So when we look at control, it's really the family coming to a consensus on whether or not there are going to be sufficient co-governance powers within the trust or within the shareholder arrangement. Co-governance powers mean things like this. At one level, the family office executives are doing their work and activities. And at another level, at a strategic level, the family will have their input. It's very important that this framework works together so that we reserve items to the family that are of a strategic importance, and we leave the operations down below with the family officers. It's important that we adopt a style of looking actively at how the family will manage control, because it's also generational. The control mechanism for a founding sort of set law, it will be quite different when it transitions across to perhaps second and then third generations. So the control mechanism should be seen as something that evolves over time and is not just a single generational aspect. Participation, that deals with who's going to be involved and what's their qualifications. Sometimes at the family level, you'll see quite stringent views on in-laws being involved. Most times they're completely excluded. At the family office level, participation is premised on being able to actually contribute and have some value. And so the family getting into some form of agreement around this or some framework around this is important, because it adds to the general hygiene of the family office. And so that we can avoid typical areas where all families fall out is you have a member that goes on, starts contributing or taking salary, and they don't really do anything, or they do things wrongly, and because they're not qualified. And so that's where participation comes in. These are just some of the key terms and the key areas that families will need to look at as they consider their governance framework. Benefits, that really deals with distributions, salary, benefits in kind. The family should be challenged to think through this, particularly where they're looking at how much they will need for liquidity purposes to actually manage their own personal affairs. So there has to be some consensus, and it has to be upfront, not as we go, on the amount that they will be pulling from the family office and how much will be available to reinvest, for instance. There needs to be a discussion about this. It shouldn't be the case that, particularly with us in the planning industry and dealing with these clients, it shouldn't be that they later find out that they have a liquidity issue with family members wanting to draw more from the family office than it can actually afford. Abuse is the final one, and really talks about managing the context in which disputes can come up. Typically in these areas, you look at keeping things confidential and keeping things within bounds when it comes to costs. And so typically alternative dispute resolution is something that we will look very heavily at in this area, but also in the more sort of flowery view on this, when you're looking at governance, you'd also want to look at greater levels of transparency, for instance, greater levels of accountability, key decisions being telegraphed with enough time. So abuse can also be a much wider category of trying to open up a system so that it's not so opaque and decision-making is seen to be representative, not just how we deal with a dispute going forward. But I would say most families will opt for a private initiative when it comes to dispute resolution and not necessarily want to rely straight away on the courts. So that's another area that needs to be discussed and gone through. And the key bit here is when we're looking at, let's say, an unstructured governance framework where we're dealing with shareholders, all of these items will need to be discussed. We'll need to be doing this at the beginning, not at the end, or not when they've, let's say, got their MAS exemption and they're up and running, and then we discuss this. It should be something that's brought forward as one of the key items on the list before they commit to structures. It's the same thing with the trust. You'll have to consider all of these and how to efficiently use them in a trust. Later on, David and I will discuss some of the limitations on using trusts and having the governance framework react in the way in which the clients would expect. And then finally, the same thing again. It becomes more complex, I expect, when you're dealing with a hybrid structure where you're having to consider both of the different frameworks at the same time. And again, the idea behind all of this is that you have a system of functioning sort of social framework where families are likely to make it through cross-generationally and without having areas that we know traditionally will trip them up. And those are the control, participation, benefit and abuse areas that we should try and tag on to. I just asked David, just from your practice, you've seen these things for many, many years, and you've been involved in a great many cases over the years. Is there one thing that comes up with, or at least a number of things that comes up all the time where the families have fallen down, that's touched on any that I've just previously discussed?
Above all else, I would say planning ahead is absolutely crucial. You've just got to recognize that if you do not structure or plan ahead and try to work out how these stresses and strains will be dealt with, then you really are inviting a dispute.
Yeah.
Let's say, and there is one long lost colleague many years ago used to say that for every dollar you spend on planning ahead, you will save $10 down the road in dispute avoidance costs.
Yeah, I mean,
worth doing.
Yeah, in terms of where families typically fall down on the framework, is it the case that there's just no framework attempted, or that the framework that they've tried to put in place is inadequate? I mean, what do we tend to see?
I would say more the former. If you're looking at numbers, it's most do not grapple with these issues.
Yeah.
Most families quite reasonably don't think there's going to ever be disputes.
Yeah.
And it's only when something goes wrong that it focuses the mind. So it's not that people are not at all structured, it's just they're not structured with a view to avoiding disputes.
Yeah, yeah. I think it's probably fair to say that with some of particularly the standardized trust deeds that we see in the market, they're very much geared up to a more investment office type platform rather than a family office with multiple generations potentially involved. And that means they tend to be very geared towards facilitating the set law rather than what comes after the set law. Would you agree with that?
It certainly can be that way, and again, in a certain sense, quite reasonably. But the key thing to all of this is what do you want? And it's the toughest question for most people, because most of us don't really know what we actually want. That is to say, to prioritize. But if you can get the family to focus on these things, then they have to decide, do they still want to have a communal structure? Do they still want everybody to be sharing one structure in the broadest of terms? And if they do, how is that to be governed? Yeah, yeah. And how do you protect individual family members from a more powerful family member? How can you make sure that the structure isn't then going to be used against the family members, which will various examples of that we'll discuss as we go along today. Yeah, it's focusing on those things which are not easy for families to grapple with. We have to be real about it. Okay. Well, moving on to the looking at the particular configurations, looking at unstructured family offices in more detail. And so this, to remind everyone, this is where we have directly held share ownership in the family office companies. The clients, for whatever reason, don't wish to use a fiduciary structure. They wish to hold it in their own names. And so the principal tools available in a common law system would be a shareholder agreement, and then amendments to what would otherwise be default M&As, and perhaps class rights as a result of that. So these tend to be the two typical tools that are used in attempting to create a governance framework and also managing any fallout or family dispute at the end of this. So from an advantages standpoint, if you're operating through a shareholder agreement, it is confidential. It's not on a register. It's flexible because it can be changed. If you have a few shareholders, then it can be flexibly changed quite quickly, and it's legally enforceable. And that's the key thing. It's a contract.
In terms of the key provisions that you would expect to see, I mean, just working on the premise that we're advising the clients to at least have a shareholder arrangement in place and not just rely on default corporate law, the key provisions that we would try and encourage if they're trying to put in place some level of governance would be minority shareholder protection. Certainly at second generation, most families will then be into all members are now minority shareholders. And so you would have typically co-governance rules being agreed. And this comes back to the discussion earlier on around certain reserved items being kept at shareholder level and not at the executive level. Typically, it would be things like agreeing to a significant change in the investment policy of the family office. So you could well imagine that the family offices or the people running the family management company decanting all of the assets into crypto would be an extraordinary event that should be elevated up to the members for discussion. And the other aspect around this is appointments of nominee directors to represent their interests. So typical minority shareholder protections, co-governance, and trying to work out where the limit is, because you don't want to run the family office out of the shareholder group. At the same time, you want to keep the shareholders away from, bringing family politics into the board. So that's the balance that's trying to be struck through a shareholder agreement when it comes to co-governance. I mean, just before I move on, David, in terms of the typical co-governance rules that we see in shareholder arrangements, is there anything else that you've seen that actually makes a difference? So typical minority protections, as I mentioned, but is there anything that you would add to that, which is useful for families to consider?
Yes, building on what I said before about everybody working out what it is that they want, they've got to try the best to reflect that in the various structures. And for those that don't want a fiduciary structure, there are solutions through the corporate model which can be utilized. What is important is making sure that the rights of the shareholders are not always just limited to majority voting structures.
Yeah,
that there lies a degree of oppression.
Yeah,
Factions of the family gang up on others.
Yeah.
And what you're looking for with the shareholder agreement is to diffuse or reduce that risk, so that you try to think as far ahead as you can on the very points that you've just been discussing.
Yeah. I mean, I've got in termination provisions where particularly family members have in some way transgressed. They've it happens, but let's say that they've diverted opportunities, or they've ended up in some sort of conflict of interest where they haven't come clean and they've been involved in the operations of the company. It might be a situation where they're a bad leaver, as it were, and we could have provisions in the shareholder agreement to effectively compulsorily call their shares to purchase their shares with the other members who haven't found who weren't in the wrong in this. Is that something that you would typically see as a way of trying to manage the behavior of shareholders?
It is certainly a possibility, because the other side of that coin is the member that wants to decamp from the family structure. Yeah, and being able to sort of cash out, albeit perhaps at some kind of a discount. It'd come at a price typically. Yeah. But managing that process is just as important as others, because you do not want to force an unhappy member of the family to be stuck with the structure if it can be avoided. Yeah. Recognizing the value of the family coming together in one economic unit. Has tremendous advantages. Yeah, and also the lack of a market, frankly, for a minority stake in a private family office. I mean, I think you can't. Yeah, you would if you had in your pocket, X% of the shares of one of these companies. There's virtually nothing you can do with it. Yeah. I've got the other one, and you would also there will be provisions which will prevent anything being done with it.
Yes,
Because
that's right.
none of the other members want suddenly to have somebody outside of the family,
Yeah.
on however a small interest they may have.
Yeah.
No one's going to buy an interest like that other than to cause trouble.
Yes. I've got the others, which is access to information and going beyond what generally the corporate law would provide for a shareholder. I think that's an important one, to bring a greater level of transparency to the financial side of the structure, so that there isn't a worry that if you're not involved in management, then you have no clue what's going on, or at least you don't have an active live appreciation of what's going on. That's probably another area that's.
I think it's absolutely crucial, because this is one of the areas where the structure can be used against the non-executive family members.
Yeah.
The shareholder rights to information, or rather the ordinary course, are rather perfunctory.
Yeah.
Because the model is to let the management get on with it.
Yes. Yeah.
These structures, that really isn't what you want.
Right. Right. Now down to dispute. So if we actually end up in a dispute, there are two bits that come up, which is exclusive jurisdiction and arbitration. Clearly, this is normal territory for a contract, and so there should be nothing particularly unusual about having an exclusive jurisdiction clause and an arbitration clause in a shareholder agreement. It should be fairly standard, right?
Yeah, indeed.
Yeah.
There's been no difficulty with these.
Yes.
Obviously, we know that any jurisdiction clause is still subject to the discretion of the court.
Yeah.
But generally speaking, in a contract will be enforced, except in very special circumstances.
Yeah.
So,
and in terms of
an arbitration provision will be fully binding.
Yeah.
In the context of an agreement.
And any award would be enforceable, and there's a global network that would achieve that.
That's right. That's very much the case. Arbitration carries all those well-known advantages. The beauty of arbitration is that you do avoid various problems. One of them being a jurisdiction dispute.
Yeah. Right.
Which arises in most cross-border situations.
Right. Right.
Simply by virtue of the fact that they are cross-border, and most of these situations will be cross-border.
Yes. Yeah. Undoubtedly. Yeah. Okay. In terms of disadvantages to operating through a shareholder agreement, I've premised a couple. So estate succession means that effectively you're owning the shares in your own name. It's not in a structure. So naturally, if you keep it that way going forward, absent a gift or a trust later on, then it will be subject to estate succession. And depending on where you are from, if you're from Indonesia, or if you're from the Philippines, for instance, then forced heirship will apply to your devolution of your shares, notwithstanding those shares are in a common law system. It could be BVI, or it could be indeed Singapore or Hong Kong. They would all look to the deceased's place of domicile to apply the domestic rules of the place of domicile at death. And so that then puts a limiting factor on the freedom that the owners of the family office will have, because typically these are international family offices. They're not domestic family offices, particularly if we're looking at it, let's say, from a Singapore perspective. The other bit that comes up from this is the fact that it is a contract and you're trying to take the contractual provisions cross-generationally. And so the successor ownership of these shares, you then have to find a way of getting the successors to actually voluntarily adhere to the shareholder agreement as it is now in place. That can be problematic, and depending on the corporate law that you're dealing with, it may be difficult for you to force someone to agree a contract, and it may give rise to litigation if you do, and they don't want to. So it ends up with a sort of referendum every time someone passes away. You end up with this sort of mechanism being re-looked at, or in the worst case, you end up with a balkanization of some shareholders are in an arrangement and others are just free range getting on with it without being within a shareholder agreement as a concession. So David, just looking at that as one of the critical sort of weaknesses to operating through a shareholder agreement, is there anything that we can add to that?
Through the shareholder agreement itself, there are limits because you're only dealing ultimately with contractual rights.
Yeah.
You're going to have to link that with your M&A provisions, which we will be discussing next. Yeah. You're going to have to make it a condition of, because you're not so much talking about succession to the shareholder agreement, you're talking about succession to the shares.
Yeah, exactly. Yes.
In terms of succession to the shares, you usually can control who can succeed and on what terms. So you'd want to be in a jurisdiction where you could impose a requirement that they do join in the shareholder agreement.
Yeah, yeah. And that,
just to take a simple example.
Yeah, yeah.
I mean, you can, if you're talking about the shareholder level, you can solve succession problems in different ways. One of them is using a guarantee company, where the membership isn't succeeded to because it would disappear on death. Yeah. So that the structure of the company becomes with the aid of an enfranchisement arrangement of unenfranchised memberships. You then suddenly have a succession structure or mechanism in that way, and it does work. You can do a great deal at that level,
right?
Relatively simply.
Right. I think that the use of guarantee companies in this way, it's prevalent in some of the market for the private trust companies being structured as guarantee companies to avoid the use of a purpose trust. But in terms of use of the guarantee company in that way for the family office, it's not something that's popular at the moment. And I think probably because haven't looked, the industry itself hasn't analyzed the options in any great depth. So we end up with a sort of rather, standardized approach. I think the other aspect,
you've got other options just without dwelling upon it. You've got voting, non-voting shares and things of this nature. You've got a degree of flexibility.
Yeah, yeah. The other aspect on the disadvantages is it doesn't provide any asset protection because clearly it's still in the estate right up until death. If there is a breach of the shareholder agreement, it's a breach of the contract, but it doesn't give rise automatically to a void action by the company if it actually involves an issue around the company. So it's primarily a contract-based remedy that you'll be pursuing rather than one within corporate law. And then the last bit on this, so that we can wrap up, is the self-policing aspect. Is that it's a shareholder arrangement, so if it's infringed, then it's on the party to the agreement to then raise proceedings or to begin the process of, let's say, going into arbitration on this, and they will have to self-fund to that extent going forward. So it's a self-policing mechanism. There's no framework of administration around a shareholder agreement. So there isn't an administrator of a shareholder agreement as such. So any other aspects on the disadvantage, David, that we would mention?
Well, only the limits of contract.
Yeah.
As you say, that there is no invalidity, but also you just have contractual rights. You don't have property rights.
Yeah. Right.
It's out just virtually by the contract that there are always the limits of contractual remedies.
Yeah. That then takes us to the sort of counterpart to this, which is the M&A amendments. And of course, the advantage flexible if you've got a limited amount of shareholders, legally enforceable, as we know, does provide some administrative framework because the directors should be acting within the powers that are given to them within the framework of the company constitutional documents. So that, to that extent, has a framework. And then there's the automatic adherence, because once you become a member, however you've got that way, whether through succession or otherwise, you're going to be bound into the statutory contract of the M&As. So it's ostensibly got a lot more advantages, or at least it's starting to have more advantages in the shareholder agreement. But if we look at the key provisions, the same thing arises. How much can we put in terms of the minority protections at the M&A level? And I think here, David, it's really a discussion around, how typically families will want to, how detailed they'll want to be with the M&As in conferring rights and protections on minority shareholders that may be named individuals, or it might be, you know, a bit more personalized rather than members as a class, as it were. So I think in terms of looking at the minority protections, what would we typically see going into an M&A as a co-governance protection? Enhanced voting rights on a particular issue, or how do we typically see this?
Well, this is what's going to be. This touches upon the major limitation of doing things through the M&A. The problem of publicity in most jurisdictions, you can get your hands on the memorandum and the articles from the registry. So there is an automatic limitation to what level of detail anybody's prepared to go into in that document.
Yeah.
So you can go a long way with your minority shareholder protections, and you can still have lots of things where when the minority interests are involved, there is weighted voting.
Yeah.
And you can always have unanimity in these matters. How wise it is another question. You need a deadlock breaker. This is a debate which is not an easy one to engage in, but the cost of avoiding that engagement is far greater down the road.
Yeah. I mean, I've tracked through that. Obviously, we can change the articles to provide greater levels of access to information, and I've also mentioned entrenchment as a side issue to trying to make this have some level of longevity. But just looking at the entrenchment, the question here is how much can we actually put into the M&As that cannot be amended going forward, regardless of what percentage of shareholding you have? Because in most corporate laws will allow an amendment of the M&As, provided you have, let's say, 75% of the vote. But is it possible for us to go beyond that and say, even if you have 100%, that you're still locked with the same provisions?
It can be achieved, but in most places, it's got to be done indirectly. The problem for most jurisdictions, as you just indicated, is the statute permits the amendment, or certainly the articles, to be amended, and that right cannot be taken away by contract or by a provision in the articles. But what is permitted, what they used to call bushel and faith clauses, that's the name of the case, whereby you can absolutely have weighted voting on particular issues. Yeah. You can just, somebody who normally just has one vote in the ordinary course can have 25 votes. Yeah. 25 times the amount on another particular matter. Yeah. That weighted voting is certainly lawful in most jurisdictions, and it will be effective. Yeah, you have to be careful who has that right going forward, and the issues. I think the takeaway for the some of the founders is that if you're operating through shareholder arrangements and articles, then particularly if you're dealing with an article, you have to take it on the chin that it can be changed when you're no longer around. You can't set it in stone unless you find a jurisdiction that can actually absolutely entrench the provisions. I think you can, of course, as David mentioned, obviously put in weighted voting, but then you have to consider who's going to have that right and whether or not they could potentially abuse it, and etc. So it's difficult. You can only achieve the continued state of affairs by effectively a golden share, which is held through another structure. So it survives the different generations. Then you're just moving the point of the problem, because then you have to control that structure. Yeah, I know. Yes. The two aspects then on the M&A amendments is bringing into bear things that we've seen on the contract side, which is exclusive jurisdiction and arbitration. I know that we discussed exclusive jurisdiction. It was a bit odd in the context of a company's constitutional documents, but I think that we agreed that, or at least you'd sort of advised that yes, you would have effectively exclusive jurisdiction, because it'd be quite leery for a court to
effectively try and deal with another jurisdiction's corporate laws. But the arbitration, though, was interesting. Having an arbitration clause embedded into the M&As, I hadn't actually personally come across that in practice. But from what you were saying is that's actually quite common.
It is indeed. Most people don't realise that, is, of course, we're all guilty of hardly ever reading the articles of most of the holding companies that tend to be used. But you may find that there is an arbitration clause in there. It's a whole raft of BVI holding companies which have provisions tucked away, and they are generally effective.
Yeah, I think isn't the attraction?
Not every single issue is arbitrable.
Yeah.
And some matters are reserved to the court, but for the most part they are there and they're very effective.
Right. I think in terms of moving on to the disadvantages, I think we mentioned the public access would be one. We've still got the estate succession because it's still going to be a personally held asset, and then the no asset protection. So we're still back to where we were on the shareholder arrangement. We've taken off a bit, but the public access is probably the one that will limit most families using an M&A as the comprehensive framework through which they will operate. Yes,
again, there are, in various jurisdictions, sort of corporate solutions to this. Those jurisdictions which don't just follow that traditional memorandum and articles of association model, but have make provision for bylaws. Those that have bylaws, the bylaws tend not to be registered.
Yeah.
And you've got a free document then, which you can tailor to your needs. It's not going to be exposed so publicly.
Yeah.
So it occupies very much the same as the bylaws of a foundation.
Yes, right. I was going to mention that.
Exactly. It's the same thing.
Yeah.
Bylaws of an American style company are the same. An Armenian company would have bylaws. Interesting, Bermuda has bylaws. So it's quite useful. And if any jurisdiction is considering to revise its corporate law, it's a very attractive thing. Not remotely contentious in terms of international regulation or anything.
Yeah.
And that would be to introduce a system of bylaws.
Yeah. I mean, that would sort of suggest that if they are wedded to a corporate version, then perhaps a watered down version of this would be a foundation, so that you can start to get to clawing back some of the privacy issues that would otherwise come about. I haven't seen it in practice, particularly in Southeast Asia, but at least that would be another tool in the toolkit to talk about.
Yes, it's not a whole lot different to any other fiduciary, in inverted commas, structure. I mean, either you're going to have an overarching holding mechanism, or you're not. I mean, your holding mechanisms can be many and varied, can't they? But basically, you're looking at trusts and foundations.
Yeah.
The issues that will arise in relation to a trust will generally arise in relation to the structure of a foundation.
Yes, yeah.
At least in the broad sense.
Yeah.
Some things don't arise.
Yeah.
But again, you can get there in other ways, as I indicated before, through the different corporate structures. And if you are very adventurous, you can manipulate property rights through contract.
Yeah. Right.
That's probably a little bit too out there for the moment, I think.
Yes, yes. Well, let's just bring it back to this one. Just to try and harmonize the documents, because undoubtedly the clients will be operating through both shareholder and M&A amendments. Which key areas would we seek to harmonize? I mean, would having arbitration provisions at both levels be something that we should definitely do, or just keep it at the M&A level?
Well, you'd want to introduce it as much as you can, wouldn't you? So it is quite common when you've got a shareholder agreement that you do try to introduce into the articles at least some of the provisions which are in the shareholder agreement. Obviously, all the private ones you're not going to do.
Yeah.
But you can reflect those and therefore render them enforceable and effective internally within the company.
Yeah, but I think the sort of final takeaway is that you probably can get away with creating a fairly complex governance structure for the family to make arrangements and agreements across the current shareholder group, that you can obviously rely on the arbitration provisions to keep disputes private and confidential, and also to keep, I guess, the time and expense involved to a minimum. And so it achieves a lot of the goals that a lot of the families want to achieve, which is some framework, a decision-making tree around what they're trying to achieve, and at the same time making sure that disputes are kept under management. The only issue that we have with this structure is that it doesn't easily transpose across to the next generation. And it means that we have compromises that we have to go through to make it work. There are clever ways around this, but looking at it in terms of, let's say, the average legal budget or interest of a client, we'd have to keep it fairly robust in our approach. So you can achieve a lot, but the issue is transposing it across generations. It tends to struggle. You can achieve a lot through M&As, but unfortunately, these are going to be publicly available documents, and families may not wish to have that much into the public domain, particularly if they're a marquee family and a name. That brings us into the structured family office, and the typical version of this obviously is the family office trust. The advantages are a lot. It's confidential, no discussion about a sort of trust register in places like Singapore. It's multi-generational. You can actually have them obviously in perpetuity, depending on the proper law of trust. It will typically sit in an anti-forced air protective sort of housing. So Singapore has anti-forced air protections, as does Hong Kong and other leading jurisdictions. It does have asset protection benefits ultimately. And it does have an administrative framework because it does have a trustee that is administering the trust according to its terms. So it actually has a comprehensive list of advantages going forward. Now, in terms of the key provisions, the co-governance powers, we can, as we know, slice and co-govern a trust. We can have it either as reserved powers to the settlor, or we can grant powers to, let's say, a protector committee. These powers we can, if we wish, particularly on the administrative side, pair out strategic decision-making to a family protector committee, and then have operations at the family office level. The issue that we've got there is, and I'll run through each of these, is how do we transpose into a trust environment what we are effectively taking for granted in terms of a contract environment, whether it's a statutory contract with M&As or a actual contract with shareholder agreements. And so the first thing I want to discuss is the use of an arbitration clause to try and keep disputes that may arise, internal disputes within the family, within the trust, to keep it private, confidential, and cost conscious and time conscious. And so for this, David, just to canter through, we know that there are certain jurisdictions that have expressed trust legislation dealing with trust arbitration. Bahamas is one. I think you've been involved with helping with that and steering that to have the Bahamian legislation dealing with arbitration. Guernsey has it. DIFC in Dubai has it. And we see that from the draft that I've seen, the Swiss Trust Act will also have an arbitration provision. But the question is this: if we're not in a jurisdiction that has legislation dealing with trust arbitration, what's the result? So if we have someone in, let's say, Singapore, local council, who's busy drafting away arbitration clauses in local trust deeds, of which Singapore doesn't have a backing law on this, what's the potential issues that could arise if this is ever put to the test going forward?
Yeah, it is absent a sort of statutory underpinning. It is quite problematic even now. A great deal of thinking's gone on with this, and various positive arguments are put forward. But the practical reality is that you've got, first of all, there is a question over the validity of such clauses.
Yeah.
The problem of usurping the role of the court still remains, and this is not at all new. This is exactly the argument that prevailed 100 and odd years ago over contractual or agreement-based arbitration. Originally, the agreements were struck down because they usurped the role of the court. That was eventually resolved mostly by statute, and we're going through the same pain in trust matters. There are various theories, various views being expressed that a modern court would not strike an arbitration clause down, given the almost universal acceptance of arbitration as an alternative curial regime. The problem is entirely practical. The problem is that if you have an arbitration clause, it matters because there's a dispute.
Yeah. If
there's a dispute, then you can be sure that one of those parties will take advantage of this uncertainty and will try to apply to the court to have the clause struck down.
Yeah.
The moment that happens, the primary advantage of arbitration is lost because you're out in the public regime, in the public world. So it's problematic. It's problematic for other reasons as well, because you can sit back and relax for a couple of years while that is being fought out.
Yeah, I mean, even if
time is everything in these cases, delaying things is usually to the opposition's advantage.
Yeah,
and so that's that.
If you were to
there are several other problems as well.
Yeah, I was just going to mention, if we had a arbitration award, how do we enforce that? Can we use the international conventions to enforce it?
That's one. There are well-known 5 impediments. One of them is legality. Another one is enforcement.
Yeah.
It doesn't have the advantage of the New York Convention, which uniformly almost every country in the world is a member of, and will enforce an arbitral award as if it's a local judgment.
Yeah.
But it's not hopeless by any means. You can still enforce your clause, but you just have to enforce it through common law means.
Yeah.
And if you have to go internationally to enforce it, then you have to enforce it in the same way as a judgment, a foreign judgment, has to be enforced.
Yeah, but I mean, the key takeaway is if you're free drafting arbitration clauses into a trust document in a jurisdiction in which there is no backing legislation, then it may be problematic.
It's not a solution. You've got problems with binding all the beneficiaries to the arbitration, which we can't go into.
Yeah.
You've got problems of representing minors and unborns.
Yeah.
And also the powers of the tribunal will not be directly suited to trust matters necessarily.
Yeah. The other one was exclusive jurisdiction. So typically trusts will contain clauses dealing with which court will hear a dispute. I put in, I'm just highlighting some of the cases. We won't need to go through, but this is another case I think you were involved with, David, as well, Crociani, Privy Council. And so where are we with exclusive jurisdiction clauses when it applies to trusts? Are the courts bound to follow the clause, or can they take their view on this? How does it work?
Well, at the present time, we have this Privy Council decision, which, as we all know, is strictly only binding in the jurisdiction from which the appeal was made. But in factual terms, most courts will be heavily influenced by a Privy Council decision. They essentially indicated that an exclusive jurisdiction clause in a trust does not have the same weight given to it as in a contract.
Right.
Court will be more readily willing to overrule the jurisdiction clause, essentially along forum convenience lines.
Yeah.
But more important, perhaps, than that, the court in that case also said that a trustee that wants to enforce an exclusive jurisdiction clause needs to have good reason to do so.
Right.
Which rather suggests that it can't do it for its own protection.
Right.
Which seems somewhat counterintuitive, because most people do have these clauses for their own protection. They want to fight in their home jurisdiction, for example, and so on and so forth. But at the moment, that's problematic. I have intimated to a number of jurisdictions that they might want to look at this and introduce provisions in their domestic law that render jurisdiction clauses binding.
Yeah. Yeah.
Which is not odd, because that's been the case within Europe since the 80s, if not 70s,
Right.
because it was always part of what everybody knows as the Brussels and Lugano conventions, which then led to the judgments regulation in the European Union.
Yeah.
And from the get-go, these since the common law jurisdictions joined Brussels and Lugano conventions, they included exclusive jurisdiction provisions for trust. So it's not, it's not bold. It's been there for sort of decades.
Right. The other one is no contest. It's not that popular, certainly from my perspective. I haven't seen it being as popular in Asia as it was, let's say, in the Caribbean, dealing with South American families. But the no contest clause effectively, and this was AN and Barclays Bank, was it provides a method by which, if you challenge the validity of the trust to the beneficiary, or if you challenge the transfer of assets into the trust, or indeed if you challenge trustee decision-making, that you can be automatically excluded from the trust. And then we had this Barclays case, which broadly agrees that can be the case. I mean, what do you make of the no contest clauses? Is that something that is mainstream, or do you think that that's something that should be handled with care?
It certainly isn't mainstream, and yes, it should be handled with care. I liken these clauses to the old Cuba or flea clauses that used to be included in trust instruments. They will more often work when nobody wants them to, or when they were never intended to, than will do any good, in my experience. They're highly contentious. They very often can be used to do the opposite of what was intended. The intention is to try to cut down the amount of disputes within the family. Perfectly laudable, quite at one level, quite sensible. It's restricted to challenges to the validity of the structure. It probably will work. It will achieve its objective. But if it goes beyond that, and this is the problem with the AN and Barclays decision, if it goes beyond that and starts dealing with the questions of administration, decisions by the trustee and aspects of the structure, working or not working, then it gets into very dangerous territory. And the problem with it, it's all well and good the cases saying that these things will work provided that they don't prohibit a properly brought claim or a bona fide brought claim. The simple fact is, you will not know whether you're on the side of the angels or not until it's too late. And you can seek declarations and such like, but then during the time that you're seeking your declaration, you're not getting the protection that you need.
I mean, is it right that Bahamas actually has statutory provisions on no contest clauses, but it doesn't deal? Does it deal with challenging trustee decisions, or only just challenging?
No, it doesn't. I mean, I had a role in that, and the intention really was to shore up the ability to limit challenges to the validity of a structure. I perhaps regret that we didn't go further and then prevent clauses which challenge trustee decision making or other aspects of a structure which you want to discharge a protector or discharge a trustee, and arguably, depending on how the clause is drafted, that could be a trigger event. But it does have that, but you may need to go further than that, because otherwise you get into this catch-22 position where you simply cannot have the trust administered properly without taking a risk. If the clause purports to go that far. I would suggest that people use these clauses with great cap.
Yeah, I think that's probably where we're going to end up in terms of the summary on this. The other one is rights of access to information. I see trust deeds where there's an attempt to actually restrict totally the rights of access to information. And we've got, again, another case that involved you, Privy Council, with the Rosewood decision. Again, where are we with this? Because is it right? Can we actually restrict access to information lawfully on the back of Schmidt, or should we stay well clear of it? When we're drafting trust documents, just stay clear of the whole issue around rights of access to information being a clause that you draft into the trust deed. What's the advice here?
Again, this is something that has to be dealt with great care.
Yeah.
Because again, I generally try to discourage people doing it, but there is some scope. But we all know that in recent years there've been a number of decisions of the courts which have said that if you limit rights to information to a sufficient degree, then the trust is not enforceable. There is no trust, and therefore the net result is that the clause restricting rights will be struck down. Now, we've seen that there've been a number of recent decisions to that effect. That's not really measuring the quality of the shall we call it, the right to information.
Yeah,
we all know it's a discretion of the court. But what it's saying is, if you, like in most things, if you go too far, it breaks.
Yeah.
So what might be possible is that you would limit some of the beneficiaries. By beneficiaries, we're mostly talking objects of the discretionary powers.
Yeah.
But you may restrict some of their rights, some of the members of the family's rights. You could say up to a certain age. Yeah. As long as you don't make it 85 years of age, and something ridiculous, and a young age, something which perhaps is sensible and not permanent. Because you can have a perfectly valid trust for unborns, or minors, and they're not in a position to enforce the trust as a practical matter. So it doesn't have to be enforceable on a day-to-day basis, but within those limits, you just got to be very careful. Information access is your biggest and most important protection against maladministration.
Yes, Finally, Bartlett clauses and Jiang Hong Lee, which is the Hong Kong case involving DBS trustees. And I only raise this because of a passage in that where, we see that there's a tension between the trust companies having to do more and more in terms of monitoring what's going on with underlying companies and underlying entities as a matter of AML law, FATF-driven AML law, and then the typical Bartlett provision, which would say that they actually can be hands-off and not get involved in monitoring the actual affairs. And there was one aspect of this decision, and I know it endorsed that Bartlett clauses are valid and etc. But it was this, the inadvertent throwing away of a Bartlett provision or a Bartlett protection where the trustee actually gets involved in what would be supervisory activity of the underlying company. And I think that it causes some issues. It was mentioned in the case, and the sort of decision was that actually the trustee wasn't exercising a supervisory role, ratifying actions that had already happened, investments that already happened, and in any event, the investments that were being made or the administration of those investments wasn't something that was grossly negligent or fraudulent or anything of that nature. But I just wanted to raise the issue around this tension between trustees having to know what's going on at underlying company level as a matter of AML law, and then seeing whether or not that starts to weaken their Bartlett provisions in any sense.
Yes, the issue will be that in the modern day, and it's not that modern. I mean, for the past 25 years, in most jurisdictions, you simply can't have trust assets which are blind to the trustee. You may get it as much a practice, but it's most unwise. And if you're a professional trustee, the risks are far too great. So you've got to know what's going on in the structure underneath. But what we have to do is separate, I think, between having knowledge of things,
Yeah.
and involving in yourself in management.
Yes. Yeah.
Of the company.
Yeah.
It would appear that the Hong Kong decision would protect you just, simply by virtue of you're still protected, even though you've got knowledge of things that have gone wrong.
Yeah.
Or could arguably be going wrong, or too high a risk that's been taken, or what have you.
Yeah.
Now that doesn't mean to say that the trustee can just willingly have all the information and do nothing with it. It's most unwise to do that, because you can always apply to the court for directions if the rest of the circumstances permit that.
Yeah.
You're not going to be a friend of the settlor or the family when you do it, if you do it without their permission, but you've got to look after yourself. But having the information on its own isn't a problem. The problem is the next step, is if you do get involved in the decision-making management process.
Right.
Well, we can say two things, can't we? We can say that if you do get involved, then anything you do will be tested by the usual standard. Right.
There we are.
We've got that.
Yeah.
That's for sure.
Yeah.
I would have thought.
Yeah.
Whether it waves beyond that, the protection of the clause is another question. I don't really see why it should have done. Obviously, the nature of that which you are doing could have broader consequences. Yeah. So you could have the metes and bounds of that, but I don't think you've switched the clause off by doing that. But you could include in your anti-Bartlett clause, you could have a sort of a no waiver clause. You could make provision for this, like you do in commercial contracts. The fact that there was a delay or a waiver of provisions of rights in a particular instance doesn't mean that you've waived all your rights. Yeah, I agree. That kind of thing. So you could perhaps manage it. Yeah. Perhaps I could also say that it's rare, isn't it, for a corporate trustee actually to have engaged itself in this way. No, it'll be subsidiary, or it'll be one of their employees. One of its employees as a director. Yeah. That you would have to become a sort of, you've got to be careful in all of these things. You don't want to be a shadow director, you don't want to be a de facto director, because the point of attack then becomes that the company then sues you. Yes. That kind of thing. But you've got to do quite a lot to get into that situation. But and over, a powerful shareholder must always give consideration to whether it's exposing itself to being a shadow director. Yes. I know that's another story, but it is part of the picture. I suppose on these, just to wrap up, I mean, if you look at this in total, if you're deploying these types of clauses, you really need to know what you're doing. You shouldn't be sort of willy-nilly putting them in. And you should certainly stand back from what you've ended up with, because you don't want to necessarily have a structure that begins to become so opaque or so protected that you actually have very limited lines of accountability. And so that can generate more dispute than if you would actually try to go the other way and make it much more open and much more representative. You're back to the question which I sort of pressed at the very beginning, is everybody has to decide what it is that they want. What's behind a lot of this is it's similar to your co-governance powers, the reserve powers trust arrangement. And certainly for my part, I see no problem jurisprudentially with a divided control mechanism. And as we have discussed separately, the United States has zoomed ahead on this, and it now has institutionalized its directed trust concept. Started off as long ago as the 80s, actually, in the Delaware Trust Code, and then started to explode at the late 90s and early noughties. Half the states of America seem to have these now. And there is even the sort of a uniform directed trust statute available in the United States for every state to copy. So it's become part of the brickwork over there. Divided responsibility within a trust is now the norm. So perhaps if that is what is wanted, and I think your point is absolutely crucial, is it what you want?
Yeah.
Do you want to have freewheeling issues like this? But if it's what you want, then you're far safer to try to do it under the aegis of a statutory structure, such as BVI, a Vista Trust. Or the Bahamas, if you wanted to go there, has got its directed trust arrangement as well. The trustee is pretty much fully protected, where there is an administrative power subject to direction of a third party, that kind of thing. If you can bring yourself within the aegis of that, and the Cayman Islands lawyers will tell you that they can achieve something like this through a star trust. The biggest question is your question. Do you want this?
In the first place, agreed. Okay, so just on disadvantages then, just standing back, is looking at the current crop of trustees that we have, particularly this is with respect to, let's say, trust companies that have a suite of precedents that they would tend to use, looking at it with the emerging family office market, particularly where it's structured family offices, and then work out whether or not the actual precedent is in any way deficient in its governance framework. Is it too single generationally, or is it too settlor-centric to not be survivable into subsequent generations? Public dispute resolution, that's going to be an issue if you're in a jurisdiction that doesn't have the backing legislation for arbitration and trusts. And then looking at exclusive jurisdiction uncertainty, that's going to be a continuing theme, I suspect, going forward. So these are the key takeaway disadvantages. Looking at the hybrid family office, just cantering through a couple of the points here, I think the ones that I highlighted was you do need to do something to bring the trust and the other shareholders together. So there should be a universal shareholder agreement in place. You do have to look at the minority protections because the trust is a minority holder, as is the other shareholders. And you do need to look at exclusive jurisdiction arbitration. You can achieve it at the shareholder level. You will have the problems internally with the trust, but at least you've got at the supra level with the shareholders, at least you're doing the best you can. But the key thing is to try and have in place at least the semblance of an agreement between the different constituencies, the trustee as against the two individuals that are shareholders. Just thinking on that, David, whether or not there was anything that you would add to the hybrid family office where we've got a trust coupled up with individual shareholders.
I think somebody's got to decide what's going to happen with those individual shareholders in terms of succession.
Yeah.
You would hope that their interests would pass directly or indirectly into the trust, but there must be a reason why they're being kept. So that's got to be managed. Otherwise, that's going to be chaos. Yeah. I'm afraid.
Okay. And then, so in summary, and just as the sort of broad guidance for members watching, comprehensive governance framework is essential. It's essential to avoid disputes. If you're operating through trusts, then you know that the alternative dispute resolutions that are available to parties that are contracting are not necessarily going to be available in a straightforward way. It puts greater pressure on you, if you're operating through a trust, to make sure the trust is robust enough to try and avoid disputes in the first place. So you would need to consider very carefully whether or not the trust that's being designed for the particular client, settlor, is becoming so opaque or aggressive in its provisions that actually it's almost going to encourage a dispute when it's next generation in office. So be very careful around looking carefully at the governance framework that you apply to a trust structure where you do not have a backing arbitration law. Evaluate the current crop of standard settlor reserve power trusts and evaluate them for the purpose of looking whether or not their weak, opaque governance frameworks could cause problems down the road for families. So don't take it for granted that already within the trust documents, they're anticipating that the trust could be used for a founder as well as for next gen without any amendments. You would probably have to use some level of amendment to achieve it. Understand and explain the limits of trust law to clients so that they understand arbitration, jurisdiction, no contest, information, reserve powers, these all come along with certain levels of overhead. You need to explain to the clients the risks of designing a trust where it's trying to mimic, let's say, a contract. With hybrid family offices, they seem to be quite popular. Do look very carefully at trying to put in place a comprehensive shareholder arrangement between the trust and the other shareholders. And as David mentioned, look very carefully at what's ultimately going to happen to the shareholders' interest going forward. Will it join the trust, or will it devolve onto a will trust going forward? How will it work? And finally, because we're operating through trusts, and particularly in Singapore and Hong Kong, there are limited statutory codes. We do need to keep up to date with developing trust law. It's important. Privy Council cases are important. The Singapore courts, the Hong Kong courts are very sophisticated. They will be looking at these cases, and they will take them into consideration when looking at the type of trust documents that would be created in this region. So that would be the last point on this. And I think just moving to the questions, coming off this for a moment. One question was the perennial family constitution. I don't know. I mean, would it be useful to use a family constitution as a method to manage some of this? My own personal views on family constitutions is they actually have a very great role to play. They have what I call a preamble role to play, which is they set the scene and they bring the families together, and they deal with the emotive issues around. But when it comes to them being used in frontline litigation and court proceedings, that's not the purpose of a family constitution. So I keep seeing this scenario come up where we have family constitutions that are trying to mimic contracts and trying to mimic trusts. And I think it's quite dangerous. It's dangerous for the people that are drafting them. And I think it's dangerous for the families that are relying on them. I also see that family constitutions can sometimes take on an Alice in Wonderland quality, where they are completely divorced from the actual reality of the legal structures beneath and what the families are operating through, and that there's no real attempt to calibrate the family constitution to the reality of the world, which is, are we shareholders or are we beneficiaries of a trust, or what are we? And I think, so they have a crucial role to play as the vanguard of the family, beginning the process of appreciating their governance framework. But I think if we just stop there, it's a bit like a letter of wish without a trust. It just stands on its own, and it probably can cause more trouble than it's worth. But I think, David, I don't know what your views are on the use of family constitutions in a kind of casual way, but I do feel that they can cause problems, and they can certainly confuse families about what's actually achievable.
Yeah, yes, it's a start. I agree with everything you've just said. It's a starting point. It's possibly a policy document.
Yeah,
but it has to be understood that unless you implement the necessary structures to support that constitution, it's not really going to do much good.
Yeah. Okay, right. We're just over an hour, and that was all the questions. So just leaves it to me to thank you very much again for spending time doing this. It's very much appreciated. We have almost 250 sign-ups this time round, and then people watch the videos on the web, the sort of podcasts afterwards. So it's enormously useful to everyone in this region that we gain access to your insights. I do thank you very much, David, for spending time doing these things. It's very much appreciated. So from there, thank you to everybody that tuned in and watching this, and for those of you that are watching the recording, thanks very much. And I think we'll close it for today. Thank you.
Okay, bye-bye.